This video takes you inside a real courtroom hearing where Judge Simpson handles a case involving Daniel MCU, a defendant who has chosen to represent himself while facing serious charges of resisting and obstructing a police officer. Right from the start, the situation becomes tense as the judge makes it clear that self-representation comes with significant risks and that the defendant will be expected to follow all courtroom rules without any special assistance. As the hearing unfolds, we see multiple moments where the defendant struggles to understand basic legal procedures, including issues related to discovery and motions he filed incorrectly. Judge Simpson remains firm and direct, emphasizing proper courtroom behavior and making sure the process stays on track. The interaction highlights just how complex the legal system can be, especially for someone without formal legal training. The hearing also touches on previous legal filings, including a writ of mandamus, which adds another layer of confusion to the case. Throughout the exchange, it becomes clear that misunderstandings and lack of preparation can seriously impact a defendant's position in court. Overall, this video gives viewers a powerful look at the reality of self-representation, courtroom discipline, and how quickly things can become challenging when legal knowledge is limited, especially in a case with serious consequences.
So I will not ask you to acknowledge. I will presume that you do indeed understand everything that I've said. Now, having said that, what are we doing with this case?
I'd like to move for evidentiary hearing or
You wish to have a preliminary examination?
preliminary examination. Yes, sir.
But do people have their witnesses available the second?
We can try, Your Honor, but before moving toward that, would the court be willing to make its inquiries about discovery? I am aware of the defendant having filed a writ of mandamus with the Court of Appeals of the state of Michigan.
Yes.
That was subsequently dismissed without prejudice by the Court of Appeals.
Correct.
Contained within that, though, there are allegations that my office has violated its Brady obligations and has not provided sufficient discovery. So I'm not sure if we're ready to move forward to preliminary exam. The defendant is saying that he doesn't have all of the discovery. That is the concern. The record I feel compelled to make at this time, though, is that the people have provided, I do believe, complete discovery to the defendant, and I believe that some of the representations that were made in this writ of mandamus that has been dismissed appear to allege that things that have already been denied by this court should be produced. Furthermore, the defendant filed a motion with no notice of hearing attached to it. So there's an outstanding motion in this case as well, no hearing date scheduled. So I'm hoping that we can sort of reconcile both of those things as whether or not discovery is something the defendant is prepared to move forward, and if he ever has filed a notice of hearing to go along with the motion that I received in this case on 11/22.
Mr. Magoo, your response?
My response is that I thought this was the hearing that we were setting for the motion. So if I have to set a motion for a notice of hearing for that motion, I will do that today, Your Honor, promptly.
What about discovery?
I'm ready to move forward on my what I meant by my discovery comment was that there's still no exculpatory evidence as far as that I did anything wrong as far as anything that they've submitted. So if it was improper for the wording, Your Honor, I apologize, but my ultimate goal is have the prosecution present their evidence against me.
I'm going to indicate discovery is complete because I don't know what you're saying, because what you just said regarding discovery didn't make any sense. As it regards the motion, we will hear the motion the motion will be heard on date of exam.
Thank you, Your Honor.
With it at that point in time. So the people would have their witnesses available on the second.
We can try for the second, Your Honor.
Preliminary examination in person, January 2nd, 2025, 12 noon, that is before me.
Thank you, Your Honor.
And continue.
As the hearing comes to an end, it leaves behind a strong reminder of just how serious and demanding the courtroom environment really is. Throughout the proceedings, Judge Simpson maintains control and reinforces the importance of following proper legal procedures, while the defendant's struggles highlight the real risks of choosing to represent yourself without the necessary knowledge or preparation. It becomes clear that even small misunderstandings or mistakes can quickly turn into bigger problems in a legal setting. The court's decision to set a date for the preliminary examination shows that the case is far from over, and the road ahead will likely be even more challenging. With charges like resisting and obstructing a police officer, the consequences are significant, and every step in the process matters. The defendant now faces the responsibility of preparing for the next stage, where the expectations will be even higher. In the end, this hearing serves as a powerful example of how important it is to understand the legal system, respect courtroom rules, and approach serious cases with the right level of preparation. It also shows that confidence alone is not enough. Without proper legal guidance, things can quickly spiral out of control. As the case moves forward, all eyes will be on what happens next and whether the defendant can better navigate the challenges that lie ahead.